Hey guys, this is Carl Miller on the United States Constitution. I'm going to go over a few things, and this might help you guys out since you're kind of new to the game. I better zoom this. Hey, cat, quit. Here are the facts. If you don't know your rights, you don't have any rights. Okay? Now, it's important you understand the Constitution, and you have to do that by reading the writings. Okay? When they signed this document, they signed as officers of the government agreeing to the Constitution and simultaneously as officers and representatives of the people in a Republican form of government. When they signed that document, that constituted an ironclad contract in writing enforceable in any court of law pursuant to the statute of fraud. Now, we'll ask, is they enforce the contract? Now all we ask is that they enforce this contract. If you read something in the Constitution and you have a good reason to believe it the way it is, they should honor that. And they should honor it in favor of you, the clearly intended and express designated beneficiary. First thing to understand is Article 6, Paragraph 2 of the Constitution. This is known as the supremacy clause of the Constitution. What it says, the Constitution, law of the lands which shall be made pursuant thereof, and treaties made or which will be made under the authority of the United States shall be the supreme law of the land. The judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary are notwithstanding in law. What that means is, if there's a state law, it can't oppose the Constitution. Now here you got Marbury, because this was in conflict. One leading case in history is this. The court said anything that is conflict with the Constitution is null and void of law. Clearly, if a secondary law comes into conflict with the first law, the supreme law would prevail over any other law, and certainly our forefathers that intended that the supreme law would be the basis for all laws, and for any law to come in conflict with it would be null and void. It would bear no power to enforce. It would bear no obligation to obey it, like it had never been written. Now, let me give you an example of today's timing. The argument is so effective it literally nullifies the Brady Bill. It nullifies the crime bill that takes away the right of the people to keep and bear arms on these 19 weapons that turned into 159. It stops 666 in its tracks. Well, the next thing you need to teach you is the Second Amendment. The Second Amendment is for everybody talks about today and probably gets railroaded the most. The next is the Fourth Amendment and the Fifth. The Second Amendment is the most vital amendment here because our forefathers had an important understanding of life, liberty, and the pursuit of happiness. That was the First Amendment. And then they turned around and realized that the right to protect the first right, they didn't have that right. So the Second Amendment instituted the right of the people to keep and bear arms and shall not be infringed. Then they started by saying, a well-regulated militia being necessary to the maintenance of a free state. Okay. The rights of the people. The Supreme Court has ruled in hundreds of cases that it's the right of the people. It means that right, that to every citizen to possess that right equally. Now you know that after infringe there is no subparagraph A, B, C, D that would stipulate that it would be an accepted infringement. So all infringement is forbidden. I asked him, what don't you understand about the word infringement? Because it says right here, if you look up in the Black's Law Dictionary. And these people, they understand that. Now, second way you can do things is, if necessary and proper, our armed militia can come together and decide to tell these people that giving aid and comfort to our enemies of our country by breaking our laws, that they have broken the law of Title 18 U.S. Code Section 2381, which says, when in the presence of two witnesses of the same overt act or in an open court of law, if you timely fail to move to protect and defend the Constitution of the United States and honor your oath of office, you are subject to the charge of capital felony treason, and upon conviction you will be taken out by posse to the nearest busy intersection at high noon, hung by the neck until dead. The body will remain in state till dusk. You understand? Okay. Now, first 10 amendments. It's important to jump to the Ninth Amendment. Enumeration of the Constitution, certain rights shall not be construed or denied or disbarred others retained by the people. This means Congress has no authority to add on to the Constitution in such a way it would take away rights previously guaranteed. The 10th Amendment. The powers not delegated to the United States by the Constitution or prohibited by it are reserved to the states respectively or to the people. The Constitution is a contract designed to live in government. When you get into police powers, you start understanding your police powers. You hear this all the time, black, so on, so. Do they have the power to take away rights guaranteed by the Constitution? Obviously, they don't. Then the Ninth Amendment clearly put a limit on that. No person shall be held for capital or otherwise infamous crime, so on and so forth. You can't be a witness against yourself, or you can't be deprived of life, liberty, or property without due process of law. If they don't give you due process, the law or jurisdiction ceases automatically. If they don't give you a speedy trial, then in the nature of the cause, and to be confronted with a witness against you, they got to throw it out. Now, it's very important here to understand it's supposed to enforce from American Jurisprudence, Volume 16, Constitutional Law, Section 97, that a Constitution should receive liberal interpretation in favor of the citizen. Is especially true with respect to those provisions which were designed to safeguard liberty and security of the citizen in regard to both personal and to both person and property. See Briers versus the United States 273 U.S. 28. In other words, it's supposed to be any liberally enforced, and it has to be in the favor of the citizen for the protection of their rights and property. Now, the Constitution is a contract in writing enforceable in a court of law pursuant to the statute of frauds. I'm asking for special performance, Your Honor, in favor of me. I am the beneficiary of the contract. The contract shall be enforced most favorably in favor of the non-preparer, and that's you. Now, I'm not going to get into this too far because I'm already like 8 minutes. I'll put a link to this. Something else I want you to keep an eye on. Something how laws get written, and then their constitutional lawyers that they hire come in and say, "Oh yeah, it's according to the Constitution." These people, you got to understand something. These people, these constitutional lawyers that they so highly value in Washington, D.C., they only studied what other judges said about the Constitution. They did not study the Constitution as it was written. They only studied what other judges said about it. And when they did that, they automatically made the judge the law, not the Constitution. They went to case law and they studied the writings of judges. Okay? So after time, they were able to show that, there was an evolution of the law. But if you look over here, it says, let's see, right here. In my constitutional law class at Vanderbilt University, one of the better law schools in this country, we never read the Constitution. He said we only read what judges said about it. Now down here, as soon as I get this tripod set up right. Ooh, I'm not doing this too well. This thing isn't right. But anyway, it says, this should not surprise us. There's no absolute truth in a universal sense. Why should there be any consideration given by judges to the original intent of the architects of the Constitution? Judicial activism became common because judges became the law unto themselves. So when they say somebody's a constitutional lawyer and it was all checked out and all this stuff, don't believe them. They only studied what judges, other judges had said about it. They're too lazy to go do this work themselves. They go, well, you know, I'm a pretty busy guy. I ain't got time for that. Well, that's where you get into trouble. They don't read the Constitution. They go, well, all right, this judge said this about it, and they lump everybody into a universal law that doesn't pertain to them whatsoever. They can twist it and do whatever they want, and you are stuck with it. So you've got to look out for these guys. They aren't real constitutional lawyers. I don't care what their plaque says on the wall. They studied what other judges said about the Constitution. So the judges themselves became the law. They can interpret things and it stands. And that's not how the Constitution was written, nor is it understood by us. Okay guys, thanks for watching.